as well as the distinguished ranking member for his leadership and the panelists for their participation this morning. If I could just start with Professor Rosenkranz, and I want to explore this issue of prosecutorial executive branch discretion, particularly in the context of the enforcement of our nation's immigration laws. But if I could just start with some foundational questions. The Department of Justice, for example, is an executive branch agency, correct?
Yes.
And federal prosecutors within the Department of Justice are exercising executive branch action in the context of their participation in the criminal justice system, correct?
Are exercising executive authority, yes.
Executive authority. Mm-hmm. Now, when prosecutors make a decision to, after initially charging someone with a serious offense, and then agree to a plea bargain to a lesser included offense, short of what they may have concluded the evidence provides that particular defendant was guilty of, is that an appropriate exercise of prosecutorial discretion within the four corners of the Constitution?
Well, I guess it depends on the circumstances of your hypothetical. It would not be appropriate if it were, for example, motivated by race or something, but on the facts you've described, if the prosecutor thought he didn't have the resources to prosecute a particular crime, or perhaps wasn't sure that he had the evidence for a particular element of the crime, then yes, that's an appropriate exercise of discretion.
And the executive branch, and in the prosecutorial context, for instance, the Department of Justice, or in the immigration context within Homeland Security, they have an ability to prioritize the nature of the offenses that they enforce. Is that correct, as an appropriate exercise of their constitutional authority?
The executive branch has authority to husband its resources in the most efficient way that it sees fit. So the president doesn't have the money or resources to completely execute every law, and so he does have to, by necessity, make decisions about enforcement priorities, yes.
Now, so you've concluded, I believe, that the presidential exercise of authority in the DACA context with respect to deferred action, certain class of individuals, do you believe that that's an unconstitutional exercise of his authority?
Sorry, in the immigration context?
In the immigration context.
Yes, I do.
And you believe that's the case because of the fact that you contend it was a wide-ranging exercise that was not made on a case-by-case basis? Or what is the foundation of your belief that it's unconstitutional?
I think there are two basic reasons. One is that it goes dramatically further than the hypotheticals we were discussing before. This is not a prosecutor deciding on a case. This is a president deciding on 1.8 million cases. And the second striking thing about it is the president deciding on exactly the set of cases that Congress considered exempting and decided not to exempt. That's what's particularly shocking about it.
So now you're familiar with, reclaiming my time, you're familiar with the criteria that has been set forth for the determinations that are made, I believe, on a case-by-case basis as it relates to who qualifies for this deferred action, are you not?
Yes.
Okay, and so for instance, one of the criteria, you must have entered the United States before their 16th birthday and be younger than 31 as of June 15, 2012. That's one particular criteria. Another is cannot have convictions for any felony offense, significant misdemeanor, or have committed any 3 misdemeanor offenses. Those are pretty specific enumerated categories. But another category which helps to determine whether discretion is appropriate is you cannot pose a threat to public safety or national security. Isn't that a pretty broad category within which discretion can be exercised on a case-by-case basis as to whether, in fact, you pose a threat to public safety or national security, that is not a specifically constrained factor that people either automatically fall within or automatically fall without?
Well, I think it's quite a dramatic shift in the status quo. So 1.8 million people will presumptively be allowed to stay. I can't imagine but a tiny fraction of them will be found to fall within that exception.
Okay, and I would just note that of these individuals, more than 450,000 have been granted deferred action, but in excess of 100,000 have been denied access or who have not received that grant of discretion, and I yield back.
Thank the gentleman from New York. The chair will now recognize himself for 5